easy. Hang on, how long are we having a photo?
Kia ora e tātou mā. We're on the home straight now, and I think we all deserve a good clap. It's a hard task that's confronting us today, but just be relaxed, like the judge said. If you've gone outside and blowing all that wind out of you, I believe it do you a lot of good. But could you kindly please take your seats and make yourself comfortable? And then I'll just hand it back to the judge. Thank you.
So we just lost two of our members. They shouldn't be too far. Can someone go see who they are? Oh. No.
While we're waiting for the rest of our panel, I took note of the photoshops that were being taken. So I'm going to make sure that we all take this opportunity to perhaps feel free to go and have a photo with these two good-looking young men in the front until our good-looking young women arrive back. So feel free. Let's start those.
Kei konei. Tawe. Ms. Gillies.
Thank you, Your Honour. I think when we left off before the break, we were on page 92.
Yes.
So turning now to the bottom of that page to discuss the issue of acclimatisation of exotic species. And over the page at paragraph 246, the Crown does not dispute that the introduction of exotic flora and fauna into Northland has had detrimental impacts on some Indigenous species. But consideration of the historical context is important, and present-day knowledge and behaviour cannot and should not be attributed to early Māori and European colonists. With the benefit of hindsight, we know now that some of these introductions were unwise. But, as stated at paragraph 250, the introduction of exotic species was an incident of colonisation that, to the extent it was specifically authorised and encouraged by the Crown, was reasonably believed to be in the national interest. And indeed, Māori did obtain benefits from a number of exotic species that were introduced for reasons of food and revenue. And Wendy Pond, in her Rangahaua Whānui report, describes the positive outcomes for Māori from certain introductions, such as honeybees. She states that in some respects there was a fine exchange between Māori and Pākehā. In 1838, a hive of honeybees was introduced at Hokianga, and the bees shortly went wild and established colonies in northland forests, and that Māori responded by gathering the honey from hollow puriri trunks and incorporating honeybees into the classification of forest fauna as ngaro. And 19th century hives were woven from wickerwork, a skill at which Māori were adept. As beekeeping spread, Māori beekeepers developed a reputation for the craftsmanship of their hives and for their beekeeping skills. And again, tangata whenua evidence in this inquiry also demonstrates the benefits that Northland Māori derived from a number of exotic species. For example, at paragraph 251.1, the Crown notes the evidence of Louise Collier, that before Te Waiariki moved away from their lands, they had sustainable and fine lives with plentiful food and a flourishing economy, in part as a result of introduced species, such as cattle, bees, sheep, pigs, and chickens. She stated that most people had their own cattle, dairy, pigs, and sheep and chickens. The ngahere were prolific and had rongoa. People ate meat, and the skins of animals were used for kāinga. Birds were also plentiful, and some people had their beehives, a great source of rongoa. Again, as noted previously, there is a lack of evidence provided to the Tribunal of contemporaneous Māori opposition to the introduction of new species. Māori themselves had been acclimatisers when they arrived in New Zealand, and there does not appear to be evidence of Māori approaching the Crown to express concern after a number of introductions occurred. Mr. Alexander describes the reaction of Northland Māori as regarding the new species as food for the pot. And the significant detrimental effects of introduced species were not reasonably foreseeable by the Crown. At paragraph 256, the Crown notes that the majority of Europeans in New Zealand had only their observations of acclimatised species in their native countries as an information source. They could not predict the effects on a country predominantly populated by birds that had not been subject to these types of predators previously. The majority of European colonizers and colonists were likely to have seen their introduced birds and animals as moving into the environment as additions, alongside which native species would continue to survive. At paragraph 260, the Crown states that as the damage caused by introduced species such as possums became better understood and an accepted view, the Crown did move to implement control and eradication programs. Clear examples of this are the various programs operated by the Department of Conservation, such as trapping and the use of 1080 poison. Turning to page 98, the Crown submits that the Crown continues to act in good faith to appropriately manage the environment and natural resources. The Resource Management Act 1991 is currently the principal legislative regime applicable to environmental management, and the Crown considers that the Resource Management Act strikes an appropriate balance between providing for sustainable management of natural and physical resources, while at the same time ensuring the active protection of the interests of Māori. Through the Resource Management Act, the majority of management responsibilities are devolved to regional councils and unitary authorities. And the Crown states that the devolved nature of the resource management framework enables local communities to be involved in the integrated management and control of the natural and physical resources in their regions. And the Crown further states that this is consistent with accepted international standards of environmental management. In stage 2 of the freshwater inquiry, Professor Gillespie gave evidence that 3 principles arise out of the Helsinki rules in relation to water at an international law, and that one of those principles is that water governance is best managed at the lowest level of the hydrological system, with environmental baselines set by central government. And in this inquiry, the writers of the reports on rural rivers also agreed that it is appropriate for resource management decisions to be made at a community level. The Crown submits that within this contemporary legal framework, there are substantial opportunities for the views of Māori and their concerns to be considered in the local government decision-making processes regarding the environment, including under the RMA, but also through the Local Government Act 2002 and the Conservation Act 1987. Since April 2017, any proposed policy statement or plan must be prepared in accordance with any applicable mana whakahono o rohe arrangement. Now, the Crown accepts that this is a recent reform, but even aside from this recently introduced regime, the Crown states that consultation with tangata whenua is provided for through a number of mechanisms. And these are set out, or some of these are set out, at paragraph 267. Consultation with iwi authorities is required in relation to proposed regional coastal policy plans, as well as proposed policy statements or plans by local authorities, by regional policy plans, by regional councils, and before giving general public notice of a proposed policy statement or plan, local authorities must provide an advanced copy of the relevant draft proposed to any iwi authorities consulted during the preparation of that plan. And then, of course, Māori have the opportunity to make submissions during the public notification process as well. At page 102, the Crown states that the RMA was already subject to detailed analysis in the Tribunal's Y262 inquiry. And the Y262 Tribunal found that although there were issues in the implementation, the Crown's obligations in developing a treaty-compliant environmental management system was to create a system that gave proper weight to the kaitiaki interest alongside other interests, and that the Resource Management Act in principle did do this. The Y262 Tribunal stated that there are many legitimate interests in the environment that must be balanced, and that there can be no standard template for environmental decision-making that privileges one set of interests over the other. At paragraph 274.3, the Crown notes the Y262 Tribunal said that the kaitiaki interest is important, and protections for it must be that more than token, but it is not a trump card. What is needed instead is an environmental management system that allows all legitimate interests to be considered against an agreed set of principles and balanced on a case-by-case basis. And as stated, the Y262 Tribunal did acknowledge that the RMA regime already provides for this, although there have been some issues in its implementation. The combined effect of sections 6 to 8 of Part 2 of the RMA is to give particular and significant protection to the Māori interest. And sections 6 to 8 are summarised at paragraph 278 of the Crown's submissions. In summary, Section 6 requires that persons exercising powers and functions under the Act recognise and provide for listed matters of national importance which include the relationship of Māori and their culture and traditions with their ancestral lands, water, sites, and wahitapu, as well as other taonga, as well as the protection of historic heritage from inappropriate use and development, historic heritage being defined to include sites of significance to Māori, including wahitapu. Another matter of national importance is the protection of protected customary rights. And Section 7 of the RMA requires that all persons exercising functions and power under the RMA have particular regard to kaitiakitanga, which is defined under the Act as the exercise of guardianship by the tangata whenua of an area in accordance with tikanga Māori in relation to natural and physical resources, and includes the ethic of stewardship. And finally, Section 8 requires that all persons exercising functions and powers under the RMA take into account the principles of the Treaty of Waitangi. In stating that the Crown considers that the RMA is consistent with the treaty, that does not mean that the law cannot be improved. The Crown's willingness to consider further reform shows that the Crown is an engaged treaty partner and willing to respond to challenges as they arise in order to better recognise the rights and interests of Māori. And at paragraph 287, the Crown states that the Crown has acted in good faith to improve and amend the RMA regime as necessary. And at paragraph 288, the Crown notes that Deputy Chief Judge Karen Fox, in her plenary address to the Resource Management Law Association's conference in 2014, did note the significant steps that have been taken by successive governments to increase the practical involvement of Māori in the resource management, leading to increased opportunity for consultation and appropriate consultation. The recent reforms in relation to mana whakahono regime are set out at paragraph 298 of the Crown submissions. And the Crown notes that the purpose of the mana whakahono arohe regime is to provide a mechanism for iwi authorities and local authorities to discuss, agree and record ways in which tangata whenua may, through their iwi authorities, participate in resource management and decision-making processes under the RMA. Turning to page 113, the Crown states that the Crown is responsible for the overarching statutory framework, but it is not responsible for the individual decisions of local authorities. The RMA delegates decision-making powers to local communities through local authorities. And this local government legislation has reflected the philosophy that it is preferable for decisions affecting the local community to be made by that community. And again, this reflects internationally accepted best practices for environmental management. But in saying that the Crown is not responsible for the individual decisions of local authorities, that is not to say that the Crown does not monitor local authorities or require local authorities to be accountable. It does, and they are. And this is set out at pages 115 to 117 of the Crown's submission. Local authorities are monitored and are accountable to the government and the community in a number of ways. One way is through the Environment Court, and this provides an important forum for regulating local authority acts and omissions. The legislative regime, through the establishment of the Environment Court, allows for Northland Māori to hold local authorities to account for their decisions made by them that affect Northland Māori, their taonga, their lands, and their interests. And the Crown notes that claimants in the Northland Inquiry District have successfully challenged local authority decisions in the Environment Court. For example, Dr. Joy Panaho gave evidence as to a successful appeal to the Environment Court in relation to the Whangarei District Council's granting of a resource consent to allow the subdivision of the Maunga Karamea block. But the Crown also holds local authorities to accountable in other ways, through the Auditor General's ability to audit performance of public entities, through the Environmental Reporting Act 2015, through the Parliamentary Commissioner of the Environment, and through other mechanisms. At paragraph 309, the Crown states that it is aware that resourcing and capability and capacity building is a large barrier for the public and for Māori to engage in the resource management processes and the resource management regime. The RMA expressly requires councils to consider ways to foster the development of iwi authorities' capacity to respond to an invitation to consult in relation to policy statements and plans. And as set out in paragraph 310, local authorities and regional councils have responded by providing budgetary commitments to assist iwi participation. 58% of local authorities, and this includes the Far North District Council, the Northland Regional Council, and the Whangarei District Council, have a budgetary commitment to assist iwi hapu participation in policy statement and plan-making processes. 42% of local authorities, and again this includes the Far North District Council, have a budgetary commitment to assist iwi hapu participation in resource consent processes. In addition to this, the Environmental Legal Assistance Fund, which was established in the year 2000, provides not-for-profit groups, including Māori groups, with financial assistance to advocate for environmental issues of public interest in resource management cases in the Environment Court. And again, we've had evidence in this inquiry where groups have successfully been funded by that fund, such as the Whatatiri Reserves Trust and the Waimarie Marae in relation to Poroti Springs. They received $14,062 worth of legal funding from the Environmental Legal Assistance Fund in 2005 and 2006. At page 119, the Crown states that the Department of Conservation acts fairly, honourably, reasonably and in good faith, and supports, including through funding, tangata whenua in conservation and environmental restoration endeavours. The Department of Conservation was established in 1987 and is the central government organisation charged with conserving New Zealand's natural and historic heritage on behalf of and for the benefit of present and future New Zealanders. And the Conservation Act 1987, which established DOC, gives a clear direction that DOC must have regard to its obligations under the Treaty of Waitangi. Section 4 of the Conservation Act requires the Act be so interpreted and administered as to give effect to the principles of the treaty. Ms. Reid-Thomas and Ms. Elliott gave evidence in this tribunal, in this inquiry, that DOC is committed to finding practical ways to work with Māori to manage natural, historic and cultural resources on the land it is responsible for in Northland and elsewhere in New Zealand, and that DOC is committed to involving Māori in decision-making within the applicable statutory framework. At page 123 through to page 129, the Crown's submissions set out the funding that DOC offers for Māori. Ms. Reid-Thomas and Ms. Elliott, on behalf of the Department of Conservation, gave evidence about various funding programs open to Māori for conservation work, including the preservation of Māori traditional knowledge. At paragraph 327, the Crown notes that the Ngā Whenua Rāhui funding program exists not only to protect the natural integrity of Māori land, but also to preserve Mātauranga Māori. And for that purpose, the program offers two streams of funding. One supporting the voluntary protection of Indigenous ecosystems on Māori-owned land, and the Mātauranga Kura Taio Fund, which supports hapu and iwi to retain and promote traditional Māori knowledge and its use in biodiversity management. And again, there are a number of examples in the Northland Inquiry District where claimants and other Māori groups have been successful in applying for funding from DOC through the Ngā Whenua Rāhui program. For example, Mr. Milan Ruka gave evidence in relation to the support he has received from Ngā Whenua Rāhui in relation to his environmental river patrol, working towards the protection and conservation of the Wairua River. But Ngā Whenua Rāhui has also funded pest control initiatives by Te Rāwhiti 3B2 Trust and reintroduction of threatened species. Other funds available are the Biodiversity Advice and Condition Funds and the DOC Community Fund. And again, evidence was that Northland Māori have been approved for at least $378,744 worth of funding through the Biodiversity Advice and Condition Funds from 2002 to 2013, and have received funding for 7 projects, adding up to $894,285 worth of funding from the DOC Community Fund, which started in 2014. From page 129, the Crown submission sets out what happens on the ground in Northland through the Department of Conservation and the projects that have been going on in cooperation with Māori, in partnership with Māori and DOC. One example is Project Island Song, which is described at paragraph 333.3. That project was to restore the eastern Bay of Islands and keep the islands pest-free. And in 2009, the islands were declared rat-free. This was a result of several years' worth of work, including 3 years' worth of hui. And DOC developed an operational plan in partnership with Ngāti Kuta and Patukeha Hapu to work on pest management plans, including the training, empowerment and employment of local people from Te Rāwhiti Hapu. Other projects include Te Rāwhiti 3B Trust Pest Management, which is set out at paragraphs 333.7 through to 333.9. The Wara Wara Forest, which is described at 333.10 to 333.11. DOC and Te Runanga o Te Raurawa worked together to organise a series of hui at Marae, resulting in the development of the Wara Wara Restoration Project, which was officially launched in 2011. Collaborations in relation to Kororipo Pa and Kerikeri Basin are described at paragraph 333.12 through to paragraph 333.14. And at paragraph 333.18, project in relation to the Puketi Forest is described. And Mrs. Moito Erua gave evidence in this inquiry that Ngāti Toro and DOC worked together to restore kokako, and that this was special because it enabled Ngāti Toro and the holders of tikanga to exercise their tikanga together with the Crown to get the job done. From page 142 of the Crown submissions, the Crown submits that there are numerous examples of Northland Māori continuing to assert kaitiakitanga in relation to the environment. The Crown submits that tangata whenua can and do practice kaitiakitanga alongside the Crown and local government under the current resource management and environmental management frameworks. And the evidence in relation to this is set out from page 143 through to page 154.